And those conflicts result in deaths, injuries, and billions of dollars of property damage. Power outages connected to these kinds of causes are massive. What you see in these images are the 2003 European blackout, and you can see that most of northern Italy, parts of Switzerland and France are all blacked out. In the upper right, you see the Northeast blackout of 2003, which took out a large part of Ontario and Canada, plus everything from New York City down to Baltimore and across to Detroit and Chicago. What you see in the lower left is the aftermath of a large power outage caused by downed trees in Detroit just this past summer. And of course, in the lower right, you see the impact of Hurricane Ida causing outages throughout Louisiana and Mississippi. Each year, the number of outages has increased substantially due to storms and severe storms. And the number of outages over the last 5 years has doubled over the prior 5 years. In addition, there are devastating effects from fires caused when utility infrastructure comes into contact with vegetation. Of the 20 worst fires in California, nearly all were caused by tree-related power line conflicts. Of the 5 most devastating fires in the United States, again, the same thing, caused by tree and power line conflicts. And it's also true with regard to non-war related fires in Europe and in South America, all being caused in this manner. Damage and loss inevitably leads to litigation, and litigation has a unique set of challenges in this space. Joining me on today's panel are 3 speakers who I'll introduce in turn. Stephen Moctezuma, Edith Lee-Payne, and Randy Gimple. The structure of this panel discussion is to start with the smallest of claims and build ourselves up to the largest of claims so that all of you can understand the scope of what we're talking about in terms of environmental litigation in this space. So, starting with Stephen. Stephen is a second-year law student here at Tulane Law School. He's the vice president of the Environmental and Energy Law Society, a junior member of the Environmental Law Journal, and a student attorney at the Environmental Law Clinic, among other organizations that he's involved in. Stephen's from Pomona, California, and graduated from UC Berkeley with a BA in philosophy. Between that time and coming to Tulane, Stephen built up a very impressive resume of doing work on behalf of really marginalized people who are either poor or imprisoned, people who have real challenges with access to justice. He also spent time working at a law firm in San Francisco called Lee-Lovett, and at Lee-Lovett, he was exposed to the massive fires that occurred in California over the last several years, including the Camp Fire in Northern California and the Thomas and the Woolsey wildfires. And as a result of that, he came into contact again with people who were being marginalized by the justice system because their claims were too small. He then came to Tulane Law School and realized that there was a program that was just beginning, and he applied to the Utility Vegetation Management Initiative to be part of this program to look for solutions to these problems. Stephen will hopefully take some of that experience with him to Earth Justice in Los Angeles when he joins them this summer. So Stephen, welcome to the panel.
Hi, can everyone hear me okay?
I can hear you.
Awesome. Great.
Well, why don't we start with the kind of small claims that you saw coming into the office that were essentially not getting justice? What did those look like?
Yeah, so when I was working in San Francisco at this plaintiffs firm, they had a number of practice areas, including environmental litigation, antitrust, employment law, personal injury, and mass torts. As you already said, I worked mostly on claims against Pacific Gas and Electric and Southern California Edison. And part of my job there was mostly client intake and managing the discovery process. And like any good law firm, we had to measure the amount of loss against the costs and risks of litigation. So if the objective material losses did not meet the threshold to overcome the cost and risk of litigation, then it would usually be recommended to not take up that client. Some of these claims would often be property damage of any sort of type of, it could be personal property or it could be real estate, is sometimes damaged businesses. And in other cases, it would be in personal injuries. Sometimes you get smoke damage coming into the house. People had affecting their lungs. Some people have emotional damage claims from fleeing the fire. So it really varied on the size and the type of claim there. And I would evaluate each one, not only just through client intake, but during the discovery process. The utility companies would send surveys so we could get a concrete number on the objective, value of their losses.
Right. So what I would expect, and correct me if I'm wrong, is that if the claim was large enough, say, for example, somebody's house burned down, that would be the sort of thing that the law firm would accept and would represent the client, correct?
Yes, well, that's kind of a yes, mostly. So if you could take a single family home and the whole thing burned down, very likely the plaintiff's firm would be able to take that up from my experience. But houses and homes do vary on the type. So if it's clear that the losses experienced by prospective clients, though they could be measured by their objective market value, were not all worth the same subjectively to each client. So if we take, for example, a structure the size of a large is sometimes the home for somebody, say a cashier or agricultural worker. If that is badly damaged, that might not make the threshold because it's so low valued comparatively to, say, smoke damage to a $2.5 million mansion where the structure and the integrity are fine, but objectively, there's a lot more loss there. Though subjectively, I think it's pretty clear that that family in the Malibu mansion probably not hurting too badly from the fact that their home got smoke damage, but versus someone who lost their home and the size of a large tool shed in the backyard of somebody else's house.
Right, absolutely. So what would happen to those people who had claims that didn't meet the threshold? They weren't going to be represented by your firm. Could they be picked up realistically by any other firm?
Potentially. I mean, maybe they could, if there's like a nonprofit, usually that is going to be able to go ahead and assist them in obtaining, justice for their claims. Otherwise, I wouldn't see why not. I wouldn't see why a law firm would go ahead and, when that threshold is not met, why any good lawyer would want to take the risk of such a objectively low loss, not against the cost and risks of litigation. And as sad as that may be, that seems to be a more structural issue, not necessarily the fault of either the client for not losing enough or for the lawyer to represent and take that risk when there's just very little recovery there.
Right. And that poses a very practical problem for a person who has a real loss, but it's just not large enough to interest the private bar. So they do have some options open to them, at least in theory, right? They could make a complaint to the Public Utility Commission of California, for example, and every state has a Public Utility Commission of some sort. It's either, it may go by a different name, but effectively it is a group of regulators who oversee public utilities, like in this example, PG&E and Southern California Edison. And it is their job to regulate those utilities and make sure that they are providing safe and reliable electricity to their customers. And in the case of a massive fire caused by one of these utilities, they clearly didn't do that. And so theoretically, a small claimant could go to the PUC and ask for compensation that way, theoretically, right?
Well, I haven't seen any theoretically, but it depends on each public utility commission, and oftentimes that isn't an avenue of justice for many of these claimants. Oftentimes,
sorry, and one of the reasons you're saying that is, I mean, you and I have both seen the rules for how to make a complaint before a public utility commission. For one thing, in most states, these are only published in English. And if that's not your language, you're going to have a problem. The other thing is that these manuals tend to be hundreds of pages long to tell you how to do this. And so if your educational level won't support your being able to do that, that's yet another problem. And then beyond that, the Public Utility Commission tends to meet during normal business hours. And if you are trying to hold down one or two or even three jobs, you may not have the time available to you to even prosecute your own case, right?
Yeah, absolutely. And the same, some of you might also be thinking the same thing of small claims courts, and the same obstacles there apply. Legal remedies are available, but they're unattainable due to the lack of privilege or for each client. So if the client does not, at the firm that I worked at, I was one of the only Spanish speakers. And so I would go ahead and have intake for most of the Spanish speaking clients. Oftentimes, even, you know, for the ordinary English as a first language American with a college degree, legal system is still, even for a second year law student, I'm still trying to understand the legal system, and it's quite confusing. So one could only imagine, if English is your second language, how you're going to go ahead and try to go ahead and navigate through these systems. If you have two jobs, if you have multiple children, if you're a single parent, other obstacles may arise too, such as the minimum damages amount. A lot of these claims will require a minimum damages amount. There's a mother who makes $15,000 a year. She's a single mother, and she got a bicycle for her son to get to school reliably because her schedule doesn't allow her to take her son to school. I mean, maybe $100, $150 is not going to meet the minimum damages amount. And so the obstacles exist in both the PUC claims and in small claims court.
Right. And Stephen, one of the other things that I thought was really interesting in the research that you uncovered in the paper that we're working on together was that the experience of underprivileged people in small claims court is not a happy one, because they don't tend to be the plaintiffs. The number one and number two plaintiffs, is, as you pointed out to me, are not poor people. They're landlords and utility companies trying to collect on rent and utility bills. So this is not a venue that they would necessarily think to go to in the first place, right?
Definitely not. Definitely not. I don't know if any of the other students have experienced this. I had a recent experience with a landlord to try to get my deposit back, because to me, that deposit is worth a lot of money. I wanted to go to small claims court, but I was really intimidated, and I have the privilege of being a second year law student. So this is really oftentimes is not an avenue of justice. Small claims court was for people who are underprivileged to sort of be able to take their claims, but oftentimes they are the defendants against hospitals looking to collect on medical bills, on landlords looking to collect on past due rent, and even in some certain cases, utility companies looking to go ahead and collect as well.
Right. And so it's not enough to just point out a problem. So you and I have been looking at what can be done in terms of a solution, because these people need access to justice. And it's either A, not available at all, or B, it's theoretically available, but as a practical matter, not actually available. So one of the ideas that you came up with is to establish a national mediation center where utility companies would agree to mediate small claims, however that might be defined in different jurisdictions. And the idea was that all these claims could be sent to students, say here at Tulane Law School, to represent the claimants, and it wouldn't matter what the claimant's original language is, because at a major university like this, translations can always be done. And with access to a professional mediator and allowing the utilities to be represented in their choice by either other students or by attorneys or just someone in their own claims department, these matters could be worked out by way of mediation that would be binding. And that would get the claimants at least their quote unquote day in court, right?
Yeah, exactly. And the fact that we would use it as mediation, as a mediation center, will reduce the cost quite substantially. No litigation costs, and the public utility companies could really just have someone in their department and sort of take a look at those claims, and instead of even doing if the mediation claim comes, they could go ahead and pay it out just by looking at it. And so, because there are nonprofits out there that will represent these kinds of claims, but they do it through court. This, I think, is another alternative that is even faster, especially for in cases where you have an objectively low valued loss, but high valued subjectively due to that person's circumstances.
Right, and so. The general idea is that the business case for doing this, we calculated somewhere around $500,000 would be the cost of doing this, which at first blush sounds like a lot of money. But if you think about it, there's 50 states. If each one kicked in 10 grand, there's your $500,000. And there's really only three possibilities. Possibility number one, nobody uses it, or not enough people use it. In which case, what you've identified is that this isn't really that big of a problem because nobody's using it. Possibility number two is it's overwhelmed. There are far too many cases that come in for the students and the arbitrator to properly handle. In that case, what you've learned is that you need more of these centers. And then the third possibility is it's right size. You get enough cases in to keep everybody busy, but not so many cases that it's overwhelming. In any of those cases, you've learned something very valuable for a very small cost per state to set up one national mediation center one time, just to see if it works for a year. And it seems like a very good social experiment to try. And it's gotten some positive attention from some of the people that we've spoken with, for example, with the now retired commissioner, who is the chair of the Public Utility Commission in Idaho, who is also the president of NARUC, Paul Schalander, who's somebody who you and all the students last year got to meet.
Yeah, absolutely. And there's incentive for other commissioners to do it, because what we don't want to do is, one problem that actually was pointed out at through the Tulane Law Review Journal is that we don't, bankruptcy of these public utility companies is an issue. that's not what we're trying to do. What we're trying to do is sort of push the reactive side to go ahead and say, like, look at all these problems. The public utility commissions have incentive to go ahead and pitch in for this kind of stuff, to incentivize public utility companies to adopt better utility vegetation management measures.
That's fantastic. Okay, thank you, Stephen. I think that what we're going to do now is we're going to switch to our next speaker, who is Edith Lee-Payne. Edith is someone who has been involved in public advocacy for nearly 6 decades. Many of you probably have seen that photo in the lower left before. It's hanging in the National Archives. Edith has been involved in public advocacy for education, housing, public safety, and civil rights for quite a long time. Her work has been recognized by all kinds of groups at the highest levels, including by Presidents Bill Clinton and Barack Obama. And she is currently involved in a number of major advocacy issues. Right now, her main association is with the Lee-Lovett Foundation, where she advocates for organ and tissue donation, but she has developed a very strong interest in this area of the law as well, as a result of something that what most people would say hits close to home, but for Edith, I think has a more close relationship to hitting close to home than for most, because it actually hit her home. Edith, these photos are probably hard to look at, but can you explain what it is that we're looking at right here in this image?
Edith, I think your mic needs, yeah.
Okay, now, thank you, Larry, for the introduction and for the opportunity to participate with this session. The photographs that you're looking at, it's actually 3 parts. The lower left is the base of a tree, and let's see, I have to put my glasses back on. You can see the utility pole to the far left. That's the utility pole, the base of the tree, and obviously the hole that the tree, what the dead tree was in. The larger image is the middle section of the tree, and connecting to my garage, and then the top portion, of course, the third or the smaller photo, is the top portion of the tree where it took down the triplex and other wires that were connected to the pole. It happened on July 4th, 2003, just a regular summer day. A brief storm, rainstorm came through. And when I say brief, it lasted all of 10 minutes, if that much, with a few wind gusts that weren't significant. But the tree, that, as you can see, is dead. And it's also an ailanthus, which is a weed tree and also called the tree of heaven. When the tree fell, I didn't know that it was a tree, actually. I thought it was just a branch. My power wasn't disturbed at that moment, or actually an hour or so after it fell. But from an experience I had a year before, where a large branch fell on my wire, I knew then that there was a possibility that it could be a problem. About an hour and a half later, the disturbance from the weight of the tree on the service drop or triplex eventually caused an electrical fire. Over $500,000 in damage. My insurance company covered about $300,000 of it, but my losses exceeded my policy limits, obviously. So the utility company, unfortunately, thought that it was not necessary to reimburse me for my losses and damages.
Okay, and I think that that's an important thing for people to take into consideration. that may not be familiar with this area is that it is the utility company's responsibility to trim, remove, and or otherwise maintain trees that are within a certain distance of the power lines to prevent this very thing from happening, right?
Exactly. And even more to that, or the area that you mentioned, in this case, it was the easement. So it's the area that they're very specific, it's DTE Energy, that they're very specific about that being their responsibility. Unlike if it's a tree in someone's yard, they of course argue, well, we don't have the right, the legal right to go and cut or remove or trim trees because it's private property. Although with a customer's permission, they can certainly do that. But in this case, this was all totally within their area. It was between two poles. So of course, the pole that the bottom of the pole that you can see next to the base of the tree, there was another one, maybe 35 or 40 feet down the easement, and of course, all the way down. So it was left after a line clearance cycle, which they were doing at that time. This occurred in 2003, as I said, but the cycle that where they were required to remove it because of the species, number one, and number two, because it was dead and they missed it.
Right. And this isn't the only one that was missed, right? I mean, essentially down your street, there were multiple trees that.
Yes. I was out of my house for 11 and a half months, staying in a hotel. Ironically, also during the August 14th, 2003 blackout, that First Energy of Ohio neglected to trim trees below their transmission lines. But when I returned home about 2 weeks later, another dead tree, also in the easement, also left by DTE, fell. This is my backyard. The top picture. This is my backyard. So another tree fell into my yard. And then the photo that you see at the bottom is I think that's the other part of this tree. So it was, yes, that photo fell into my neighbor's yard, and that tree was also in the easement. So 3 trees were left by the utility company, all that should have been removed, all within their area, and each of them falling. But my home was the only one that caught fire. The other trees didn't have any contact with utility lines at all.
Right, but they could have is the point. And the issue here is that through failure to engage in proper vegetation management, the utility here wound up being the cause, in effect, of the hundreds of thousands of dollars of damage that were above your property, your insurance property limits, meaning those damages yourself. And so there was nothing more you could extract out of your insurance company, but you did work on going after DTE in this case. And that, I think, is something to really capture the imagination, because you're not an attorney and you're going up against a gigantic corporation that has a whole fleet of attorneys working for them. And that takes a lot of energy, a lot of time, and a lot of focus.
Yes, it did. It wasn't that I didn't retain attorneys, because actually I did. But once their names were submitted to the court as being my representative, suddenly they were no longer able to represent me. So I ended up having to write my own briefs and, be my own attorney and just be a self-taught attorney. And I think I did quite well, but it's kind of hard to go up against a power company that literally and figuratively that has some control that's sometimes not above the law.
And what we're looking at here, the next several images, these are all things from your own trial notebook, essentially. So Edith really did learn how to do these sorts of things on her own.
Yes.
So looking at this, this is line clearance tree trimming policy, essentially, or at least in part. And the highlighting is yours. And what we're looking at here is it quite clearly says that that the trees need to be removed under certain conditions, right?
Yes, it says because of their ongoing preventive maintenance program, that they visit areas every 4 to 5 years to clear trees away from pole to pole lines. And their first step is to survey, which they do to determine if a tree needs, which they say they do, requires tree trimming or removal. And under certain factors, they will do one or the other. For safety reasons, and I underscore this in addition to highlighting, they are required to maintain certain distances of vegetation and with their energized wires. For the primaries, although it doesn't explain this in detail, but for the primaries, it's 10 feet. And for the secondary lines, it's a minimum of 4 feet. And they take so much else into consideration. And that's not only do they use certified arborists, but those arborists are trained to know the species of the trees, the growing patterns. They know how to directionally prune. They factor in for weather conditions. So to mitigate the damages that people can sustain, homes, properties, if these things are not met, as as they say, they factor in for the weight of ice and high winds and things of that nature. And so when a utility company gives you this thorough of an explanation of what they do, what they know to do, how to do it, how precise and in detail, then you expect, as now I think we're up to 156.5 million customers around the United States, we expect our utility companies to practice what they say they know to do. So when they don't do it, and then added into that, these aren't new companies. DTE has been in existence for 150 years and have been regulated by the Michigan Public Service Commission for almost 100. So there comes an expectation that the utility company and the regulator are doing all that they can, as they say, to ensure that we have safe, reliable service.
Right.
But that's not happening.
Right, and so you wrote to the Public Service Commission, which is the PUC for Michigan. The Michigan Public Service Commission wrote back to you with an explanation that confirms what you're saying, but
Yes.
provided essentially no real relief for you with regard to your situation, right?
Absolutely. They sent this letter basically saying the same thing that DTE Energy said. I think they were called Detroit Edison at the time. But what's required, that what their expectation of the utility companies to maintain the right of ways to provide the safe, reliable service for electric customers, and the standards that they are, the industry standards that they are to recognize that their line clearance contractors must follow industry recognized guidelines for tree trimming and to adhere to the National Electric Safety Code. So again, the regulator reiterated what the company, what DTE Energy said that they were supposed to do, yet a tree fell on my line, caused a devastating fire. Thankfully, no one was injured. Another tree fell, a year later, and then another tree in my next door neighbor's yard. So it just constantly happens. And the photos that you referenced earlier about the power outages, there were 750,000 or just over 700,000 people without power of DTE customers alone. It didn't include Consumers Energy this past August. So the company's not getting better with their line clearance, and that the reason there were so many power outages, we didn't have any cyclones or hurricanes or tornadoes. It was some high winds. I don't think there were any red flag days. The day of my fire, it wasn't a red flag day. It was just a summer day and a summer storm. So they're not doing what they're required to do to mitigate the kind of damages that people continue to experience. That includes not just property damage, but injury and death.
Exactly. And, again, getting back to really basic facts, the tree that hit your house that caused the fire was already dead when
Yes.
it fell. This is a tree that ought to have been removed. This is not, well, maybe this, that. No, clearly it needed to be removed because it was already dead. But beyond that, even if it was alive, this is a nuisance tree that is always supposed to be removed. And
Yes.
it was within these right of way, it was within their easement to access their power lines. And it was the kind of thing that was supposed to have been removed quite some time ago by them. And regrettably, the response that you got from the Michigan PSC gave you a lot of general information, but nothing really specific to your case. So we go into the specifics of your case, and I apologize, this is a little hard to read, but what we see is this is from your expert or your insurance company's expert, correct?
Yes.
And what did they find here? What were they showing in this letter?
They are referencing, I wish I found that page. They are referencing DTE's investigator, Mr. O'Callahan, claimed that the Michigan Public Service the MPSC's tariff, Book 9, which is also theirs, it's approved by the MPSC, but he makes mention of the wind gust. I believe this is what I'm reading. I don't know if I can see this better without my glasses.
Yes, so what it's saying is that there was a wind gust that day of 46 miles per hour.
Okay. And just, but just let me say, but just that in itself, where was it 46 miles an hour? There's no way that their investigator or anybody else can determine at what point in the Detroit metropolitan area or their 2.2 million customer service territory area was there a 46 mile per hour gust wind. That didn't necessarily have to be the case with me, but even with that said, according to it's the Beaufort scale, and I think that's the other thing that Mr. Fricke referenced, that would not have been enough to have taken down a tree. But the fact that this particular tree and the others that fell were dead, there were no roots. We could have just leaned on the tree or blew hard on it and it might have fallen down. But the bottom line is it shouldn't have been there to begin with. They should have been removed by the utility company.
Right. So DTE took the position, though, that this tree didn't just fall down. They took the position, and I think we're quoting here from their brief, that the tree was picked up and thrown 9 to 10 feet by a 46 mile per hour wind.
Yes.
That's not a tornado by any stretch. The tornado, you'd expect such things. But this doesn't really comport with that, correct? And in fact, your fire and forensic expert agrees with you. It's just not possible.
Right, exactly. What was even more disturbing about this is this was repeated in many of the briefs that the energy company's attorneys argued on their behalf. And I, of course, questioned the judge for seeing the evidence. And those first 3 pictures, by the way, that that were on the screen, those pictures were actually exhibits that DTE presented to the court. So the pictures totally contradict the arguments as stated in these briefs by their attorneys. So it was just odd to me that at some point I would have expected the judge to say, well, wait, now there's a conflict, because certainly I'm raising that question, as was my insurance company's attorneys. but it just didn't seem to matter.
Yeah. So what's the ultimate disposition of your case? Has it concluded yet?
Well, the judge prematurely threw the case out. I then took it to the Michigan Public Service Commission that didn't want to hear it. They kept rejecting my complaint, saying that it wasn't a prima facie case, although I submitted to them a document of 332-page document that had much of what you see here, as well as other testimony and photographs and things of that nature. I did finally get to have a hearing, but again, it was the same kind of instance with the administrative law judge, that they just didn't want to say anything against the utility company. And they eventually wrote me a letter asking me not to ever contact them again.
All right. Well, obviously not a just result, given the level of damage that you incurred for something that was clearly not your fault. It's not as though you didn't have insurance at all. You did, but you exceeded the limits of the policy. And
Yes.
that forced you into a position where you needed to take on DTE yourself. The lawyers who initially agreed to represent you dropped away for whatever reason, and now you're left on your own with roughly $200,000 worth of damage, which should be enough to interest the private bar, but for whatever reason didn't. And you wound up working hard to put together a very coherent case. You learned everything that was going on in your case, and yet there was essentially a denial of a fair resolution to you, based on the evidence that you've got here. And so the point is, you didn't leave it at that. As someone with decades of justice advocacy on your side, you realized you're not the only victim in all of this here. I mean, and it's not just DTE. This is the sort of thing that happens every day all across the country and requires resolution. And there needs to be solutions. And probably one of the best ways to get that done is to train attorneys on how to handle these kinds of cases, something that's not really being done anywhere except now here at Tulane.
Right. Absolutely. It's extremely important that attorneys recognize the responsibilities of their clients or what their clients are due. But it's also, I mean, not only was I failed by the utility company, I was also failed by the state of Michigan, by the regulators that were put in place, enacted by Public Act 3 of 1939 to regulate electric utilities or public utilities. And because there are things in place that even say specifically that, I think it's 460.10, that says 460.10C, that says that a utility, that a utility can make a person whole that's been harmed if they fail to provide that safe, reliable service. So there are things in place, as there are things in place that if a customer does something to the utilities equipment, to their meter or to their wires, or cause any damage, without question, and it explicitly explains in the regulations that the utility company can be compensated, that the customer is obligated to replace it. And it's not a certain amount, like the people that had the experiences with the power outages and lost hundreds or thousands of dollars in food. The utility only wanted to give them a $25 or $35 credit. But on the flip side, if a meter is destroyed for whatever reason, or by whomever, it's not a credit that the customer is able to offer the utility company, they have to pay it in full. So utility regulators across the country, utility companies across the country have to be more responsible and accountable to the people to the citizens who rely on them, trust them. Every time we flip on a light switch or use our electricity, we expect it to be safe. We expect it to be reliable. And I'm sure at least 95% of people don't know that when their power is out, when they're experiencing a power outage, that the power is still on. Anywhere on the circuit of that line, if there's vegetation present, it can cause the power to be disturbed, cause overvoltage, and that person can experience an electrical house fire, as I did, and as others have. So more needs to be done, not just by the attorneys, but if the attorneys are going to do it, they need to make sure that they know the rules of the respective states, what the regulations are, and they need to advocate to the best possible way to make sure that people get the justice that they deserve.
Thank you, Edith. And with that, I think we need to pause for station identification. Alex?
Hi, everyone. Thank you for coming. If you are a CLE credit seeker, I'm going to release a quick poll. The code word for this panel is gold. So please choose the appropriate answer on the poll. It just launched.
Thank you, Alex. Okay. Sorry about that. Okay, so we've gone from very small claims to a large claim for an individual to now let's go to the unbelievably huge claim. Randy Gimple,
Can I ask the moderator
partners of San Francisco-based Carlson, Calladine, and Peterson. With an undergraduate education at both Furman University in South Carolina and the University of Madrid in Spain, he earned his JD from Syracuse University College of Law, where he served as the lead articles editor of Syracuse Law Review. Randy represents parties in cases involving catastrophic fires, explosions, floods, earthquakes, equipment failures, and other mass torts. Over the last 3 decades, Randy has litigated several dozen wildfire cases in California, Texas, Oklahoma, Washington, and other states, and has also handled large flooding events in those states as well. Randy has an in-depth knowledge of forensics and forensic investigation techniques, the admissibility of technical and scientific evidence, tort liability, government liability, inverse condemnation, and other matters relating to mass torts. He is an AB-rated lawyer and a member of the National Fire Protection Association. He's an arson investigator and was recently selected by the Institute for the Advancement of the American Legal System, where he has served as on a committee developing protocols for conducting discovery in mass disaster litigation. Randy's going to be speaking to us about exactly that, going from small to medium to now unbelievably huge. What do you do when a power company has a failure that winds up, say, burning down an entire county? Thousands of structures destroyed, maybe 100 people killed or injured, and and millions, if not billions, in property damage, cross claims all over the place, government liability, perhaps. Randy, what do you do?
Yes, thank you so much, Larry. And it is a little daunting to follow Edith, someone who I recognize as a civil rights leader, and also one who is a very quick study in how to litigate these cases. Unfortunately, I'm sorry that had to happen to you that way, Edith. I'd also like to thank Charles Lally for putting this together. For you, those of you who don't know him, he's an extremely bright student at Tulane. And we're lucky enough to have him agree to do some legal research work for us over the summer, and we're looking forward to that. So with that, where would you like me to start, Larry?
Well, Randy, let's start with who you might be representing in, say, a hypothetical mass tort, or unless you want to use an example of one that you've done. For example, the Bastrop fire, you were lead counsel there, which was the largest fire in Texas history.
Yeah, sure. It was not, the Bastrop fire was not dissimilar to others I've handled. So, yeah, I'll use that as an example. It was a collection of 4 fires that actually started on the same day in a small town in Texas, east of Austin, back in 2001. There were at least 3 instances of power line contact from trees in an area that had, shall we say, vegetation management challenges because of the number of trees and the deaths of trees and the drought that they were experiencing. But it is a good insight into how these things develop and where they go. First of all, with that fire, as all others, I and other lawyers, I'm mostly on the defense side. Let me come clean on that. Most of my work is not representing utilities, but representing the companies that contract with them. In this space, I'm often representing the utility vegetation management contractor that they've hired to do the kind of work like Edith was talking about, of maintaining proper clearance between trees and power lines, consistent with the regulations, and importantly, consistent with what the utilities actually hire us to do. So using Bastrop as an example, on that fire, like all others, I and even the plaintiffs bar, we are tracking wildfires in real time, constantly. I mean, right now, my staff is tracking the 3 fires that broke out in the Florida Panhandle, as well as several others here in California. It's become a very sophisticated, a very large industry, if you will, in litigating wildfire cases. I see many of the same plaintiffs' lawyers in Texas that I would see in Washington, that I would see in California or Oregon or Oklahoma. And so we have developed a certain way. There's a certain process that's generally employed, and I'll walk through that for a sec. So I'm watching this fire in Texas, and I get a call one Sunday morning from a client saying, well, I had advised a client, hey, if you did work in this area of Texas, you may want to look into this because these appear to be tree to power line contact fires. About 6 o'clock the next morning, Sunday morning, I get a call saying, yeah, we did do work in that area. How soon can you get here? So myself and my team, we were on scene before the fire was out, beginning our investigation. And I'll get to that in a moment. Before I talk about, the investigation that the outside lawyers do, nearly every one of these, certainly the large ones, government agencies will be the first to investigate. And here in California, that would be an entity called CAL FIRE. In Washington, it'd be the Department of Natural Resources. In Texas, it was the Texas Forest Service. And they go out and they inspect the scene, primarily with first and foremost to find out, is there criminal activity involved? And they will treat the scene as a crime scene and keep people like me and other private persons out until they've done their scene evaluation. And that proceeds kind of almost like in a CSI fashion, if you will, like you'd see on TV, except specific to fires. As I think Edith experienced with the expert she had, they're looking at things like burn patterns to help them identify and walk back to where this fire may have started. They're interviewing witnesses, they're identifying and collecting important evidence. They may do a survey of the scene, they're mapping it, they're identifying all the critical components of the scene. They may hire an arborist themselves, these governmental agencies, to help assist them in determining what happened. And so they get all of this together, and it can take months. I've seen times where it takes over a year for a governmental agency to issue a final report on the cause of the fire. Meanwhile, we lawyers, we're not waiting. And we're not just accepting at face value whatever the governmental agency happens to say. We're doing the same stuff they are as soon as we can get to the scene. So we're out there. I'm a big proponent of the lawyer actually having boots on the ground, so you know what you're talking about. So you've been there, so you've seen the area, so you kind of reach your own conclusions as to the not just the immediate area of the fire scene, but I like to know the demographic of where I'm going to be litigating, where my client's going to get sued. So to me, it's very, very important for lawyers to take an active role in orienting themselves, not just to the fire scene, but the community, the people. I always tell my people, even though you're on the defense side, people lost their homes. You owe it to them to give them the courtesy of your attention and your compassion and your consideration. And so I will tour areas to look at the damage so I have a better feel for it, so I can relay it to my client as to how bad it really looks and how bad it really is. So that's kind of the initial. And another standard procedure we typically use in these situations is I will get an arborist involved very early on. If a tree hit a power line, something happened with that tree. It could have been a completely healthy pine that just got blown over in incredibly high winds. It could be something that was dead, as Edith experienced, defective, dying, or otherwise a hazard that somebody should have picked up. So the arborist is critical to that. We will also typically bring in, as part of our team, a survey crew with laser-based LiDAR surveying, and they can recreate the scene with an accuracy down to a matter of fractions of a millimeter, create 3D models of it for later use. We'll sometimes bring in electrical engineers to find out, all right, that tree hit that power line, but guess what? The power never went off. What was going on with the design of that power line? Were the fuses the right size? Why didn't they shut off the power before this happened? So sometimes electrical engineers get involved. We can bring in fire behavior analysts as well. I'll use the Bastrop fire as one example. There we had, as I indicated, at least 4 different fires break out within, I want to say, a couple hours. We've had other situations, like there were fires in Napa and Sonoma County where there were some 22 fires that broke out within a few hours. I was special counsel for the state of Washington on a case up in Washington where there were 4 fires that broke out in a very short period of time. And I was hired to defend the state of Washington in that case. And so fire behavior analysts will help you suss out which fire hit which areas, if they merged, when did they merge, what effect did one have on the other, so you can segregate the fires somewhat. You know, if, for example, I'm telling my client, hey, I think you may be liable in fire number 1, then their next question rightfully is going to be, okay, how many people do we need to compensate for fire number 1? Well, if there were 3 other fires, we need to parse that out and figure out which fire impacted which property and which plaintiff. We also bring in GIS mapping experts, and GIS is a graphic information system that is extremely valuable in our practice. In fact, everybody on my team is required to have a facility with a knowledge and a base in how to use GIS-based systems to do everything from overlay parcel maps over a fire perimeter to see who's in what location, what the values are, what the properties look like. It could be to overlay different types of vegetation to get a handle on what fire behavior characteristics may have contributed to cause some vegetation to burn, but not others. We also use meteorologists, as Edith experienced with the case she had, where there was a question about whether the winds were so extraordinary that nobody should have anticipated them. And I will tell you, Edith, I totally agree. 46 miles per hour, yeah, it's a big wind, but it's not so out of the realm that somebody shouldn't predict it or see it coming. Other things that happen, we'll hire modeling experts to try to recreate what the scene may have looked like immediately before the fire, or maybe more importantly, the last time my client had crews out there to do the work. And then, of course, we hire vegetation management experts, and these are folks like Larry, and I see we have another gentleman on the line, Steve Sislovitz, who has actually served as an expert for me in these cases. And what they look at is, did the utility have the right standards in place? If so, were they followed? Did my client and others involved follow the reasonable industry-based standard of care in what they were doing. Now, while all of this is going, and I will point out one other thing, it's not just the defense side that's doing this. The lawyers who handle large wildfires in the plaintiff's bar, they're doing the same thing. Apropos of this Bastrop incident, so I show up there, I'm walking down a dusty Texas road in the middle of nowhere. I turn a corner, and who do I see but a couple of people I know as lawyers from other cases. I see an expert I know from another case. So it's a very predictable conversation. And basically, all right, so what do you guys think? What do you got? How many clients you got? Who's your client, Randy? And that we get something of a cooperative investigation strategy going, but all the time, and this is going to be important for some comments I have later, we're each doing the same thing. And the governmental agency has done much the same thing too, in terms of the investigation. So while we're all doing this, the plaintiff's lawyers in particular, they have an additional burden on their hands. They got to locate and meet with and sign up potential clients. I've seen them do that with billboards. I've seen them do that with TV ads. I've seen them do it with town hall meetings, door-to-door surveys, referral networks, you name it. And they need to get enough people together. And this is kind of apropos a little bit of, I think, Stephen's experience. They need to get enough people together to make it worth their while to litigate these cases. All due respect, Edith, the people I deal with on the plaintiff's side, they're not going to invest a lot of money in a $300,000, $400,000, $500,000 case because it could cost that much to litigate it. So they need to get a sufficient mass of plaintiffs, if you will, to make it worth their while to litigate. On the defense side, while we're doing all this investigation, I'm also dealing with my clients, right? Letting them know what we found so far. If I suspect early on that I think we may have liability, I consider it my ethical and frankly moral obligation to make that clear to the client up front. That, look, we're going to fight within the bounds of the law as best we can, but I want you to know at the end of the day, you may be paying money. So, and that serves a couple of purposes. Number one, and probably most importantly, it is required under the rules of ethics that I be straight with my clients, that I tell them the risks going in. Secondly, it's important to gauge and help develop their expectations and help control their expectations going forward. So if the day of reckoning comes, it doesn't blindside them. And then thirdly, and this probably should fall as at least a number two, sometimes you just gotta compensate people. That's just the way it is. And I consider a big part of my job, not just defending my clients, but making it clear to them when it's time to give up, it's time to settle. I'm mindful of an old phrase from a U.S. Army cavalry manual, which said, when your horse dies, dismount. I have had to have that conversation with my clients multiple times. And fortunately, I've been doing this long enough when the horse does die, they will crawl out from underneath and do the right thing. So in addition to dealing with the client's concerns, fears, sometimes fears for their company, I'm interviewing our own witnesses. And these are folks who trim trees. These are not your standard, these are not executives, right? These are people who sometimes, Stephen, don't speak English, so I have to communicate with them in Spanish. They're concerned about their jobs. They're worried about losing their jobs. They're worried about maybe somebody's going to come after me for a crime. So I'm dealing with that as well on the defense side. We often get requests for information from public utilities commissions or other regulators or governmental agencies for information. I've had several situations where DAs want to interview my clients and I have to participate in that process. And by the way, you can't say no. I wish you could, but you really can't. You have to go through it. And then a huge part of it is dealing with the client's insurance companies. Most large companies, at least the ones who have any hope of viability in the wildfire space, have insurance for this. And I will talk a little later about the challenges of trying to insure these risks. But those insurers, they rarely just step up and say, yeah, don't worry about it, we got your back. There are discussions. You can have situations where maybe there's 2 or 3 insurance policies in play, and the 3 insurance companies are fighting over which one is really on the risk, which one's on the hook. You may have times where an insurance company wants to just pay out their limits and run away when the client wants to defend, and you have to deal with that. All the while, the insurance company needs itself to figure out, they're doing their own kind of calculation, right? They're figuring out, all right, how much could this end up being? And then they have to set that money aside. In some places, they have to do that by law. It's called setting reserves, and they have to set their reserves aside. So the idea being, we don't want insurance companies to have $100 million in claims and then pay out all the money they have on one claim, only to later on have another claim. So they need to set reserves for predictability and for allocation of their resources. And that's something they always want to know right away. How much is it going to be? How much is it going to be? And as defense counsel, it's my job to try to get them that answer. Probably more importantly, it's my job to initially explain to them why you can't just yet. This just happened. We don't even know who all is going to sue. There may be a 3-year statute of limitations. So it's too early to tell. I'll give you another little anecdotal story. I had a client once I was involved in several fires in San Diego from 2007. I had a client once who was just very insistent. She was a top corporate counsel of a major company, and she just would not take "I don't know" for an answer. So I finally said, look, fine, tell your board it's $1 billion. She said, I can't tell them it's $1 billion. I said, well, then you're going to have to tell them to wait, because we just need time to evaluate and analyze the damages. At the end of the day, the damages turned out to be $1.1 billion. So unfortunately, I took a good guess. Fortunately, we did get a good deal for the client, and they were happy with the result. So that's everything that goes on before anybody's been sued, right? No lawsuit's been filed. We're doing all of that, both on the plaintiff's side, as I've described, and on our side, as well as the governmental agencies. Then once you get into litigation, then, candidly, for the uninitiated, it can be something of a meat grinder. And it looks like, not everybody is as strong as Edith to wade her way through it. But it can be extremely difficult, even for experienced lawyers. There are seemingly interminable rounds of written discovery, which would be interrogatories, requests for production of documents. And of course, whenever lawyers engage in an activity, they have disagreements, and they can disagree about anything. And when they can't resolve them, they got to go to court. So there are motions after motion after motion over, did they provide me all the documents they were required to provide? Is that really an appropriate answer to an interrogatory? And that can be extremely time consuming. And then we get to the depositions. There are multiple depositions that take place, from, you name it, the initial investigator for the governmental agency, to every employee who may have touched that tree or seen that tree or could have seen it or could have touched it, to the electrical utility people, sometimes going all the way up the corporate ladder. I have sat across the table from the CEO of major utilities here in California who couldn't avoid having to testify, and they had to testify. It's not uncommon in a really large wildfire case to have 100 or more depositions be taken. And then, of course, you have the multiple legal motions about discovery disputes, as I talked about earlier, motions for summary judgment or summary adjudication, like the one that Edith had to face down. Another area is class certification. Sometimes lawyers will try to, class lawyers, in fact, I think Leif Cabraser has tried this before, will try to have a class, set up a class action of people who were burned out. And that requires a very significant, sometimes extremely detailed evidentiary hearing about whether the case is appropriate for class treatment. I've handled 7 of those in mostly wildfires, but other mass torts like flood as well. And all 7 times the court refused to provide certification. I'll be happy to explain why it's later on if folks are interested. So you take all of that together, at least in my experience, based on my database of some 30 plus years of doing this, I think I've not crunched the numbers. I didn't really do a full averaging, but I'd say on average for a large wildfire case, you're looking at minimum 5 years between date of fire and date of anybody getting compensated. So that's the way it rolls out. And if it sounded like I was kind of whining about it, I'm not. I mean, it's my business. It's been my profession for over 30 years. And I find it challenging, intriguing, and am always trying to do the right thing.
Great, thank you, Randy. One of the things that you mentioned earlier was that there are circumstances where fires can combine and can come together. And my understanding of fire science is sometimes the fires are drawing one to the other. They're pulling towards each other, and that in fact they can create their own weather patterns. Is something that we saw, in fact, with some of the intense fires last year. And as you mentioned, one of the things that you need to look at as a fire investigator / attorney for a client is that the cause of one fire may be different than the cause of another, but the fact that the two have come together because they're in proximity to one another, that creates another dynamic as well, right?
Oh, very much so. A forensic, factual, and even a legal dynamic. On the forensic side, as you point out, fires can influence one another as they get closer. So let's say I have a situation where it's a tree to power line fire or contact that caused fire number one. Fire number two was a vehicle fire, but the two eventually merged. It's not uncommon for plaintiffs' lawyers to argue that my client should be responsible for both, for the damage caused by both, because without the larger wildfire, the vehicle fire wouldn't have gotten out of control. And so that's one of the types of things we have to deal with. I will say, I generally find that the most significant indicator of what a fire is going to do and where it's going to go is wind. And I think most experts would agree with you. It's really the direction that the wind is going, coupled with the topography. As we know, fires are going to move uphill more quickly than they are going to back downhill. And then thirdly, the type and dryness of the vegetation involved, which candidly is only getting worse in the age of climate change, which also has an impact on the cause of these fires that no one is yet really addressing and won't address until we get our arms around the climate change issue.
Right. Thank you. And another thing that you mentioned is that some of your clients or a number of your clients are the companies that are actually performing the vegetation management itself. And both you and Edith mentioned the idea of cycle trimming, but which is the predominant way that vegetation management is done throughout the United States. Probably 49 out of the 50 states do it that way, but it's not so in California. Just so that people listening in are understanding what that means, if you think of an electrical circuit like a racetrack, and you have your vegetation management crew trimming trees, they start at the start line and they work their way around, and it might take 3, 4, 5, 7 years before they get back to the start in order to do it again. So what they're trying to accomplish through that methodology is essentially 7 years worth of vegetation management as they get to a location, so that theoretically when they get back, if they're on a 7-year cycle, then theoretically when they get back, it should be ready for 7 more years worth of work to be done right then. In California, though, they do it differently. In California, it's more spot work. They figure out which trees need to be cut or trimmed or removed each year, and they go to those locations. So they wind up putting more miles on the road, if you will, but they are doing an as needed kind of process. And in some cases, especially with the larger vegetation management companies, they're operating both in and outside of California. And that means that they're used to doing things both ways. Does that have any impact on potential liability if there's an argument, like say, for example, in Edith's case, that, hey, this tree's been dead for a long time, we should have removed it a while ago. And the tree company might say, well, it wasn't part of our cycle this year.
Yeah, it does have an impact, and I'll explain how. First of all, I do sense that utilities outside of California are starting to get away from the idea of just work a whole circuit from end to end. Because I think they've recognized that, yeah, in mile 1, you may have trees that pose a fire risk, but then in miles 2 through 19, you don't, yet you're still sending resources there. But then in mile 20 to 21, you do have a tree problem. So companies, in fact, just yesterday, I was in a deposition with a witness explaining that in a Washington system where they got away from that. And instead, what they would do is they would create what they call polygons, which are basically just areas on a map where they've already identified these are the areas that are most prone, that need the most urgent work. So they'll do it that way. They will also prioritize circuits based on various different matrices as to their reliability and whatnot. You do need to be careful, though, with the idea of just going out and grabbing those problem trees. And here I'll harken back to that Bastrop case. In that case, we and the utility had trees dying all over the place. I mean, one witness testified, and I've seen this in California, Washington, and Oregon as well. One witness testified, I would drive down the street one day, see 2 dead trees, write them up for work. A week later, I'd come out and there'd be 2 more dead trees. But what this utility was then doing is every time there was a dead tree, they'd send one of my crews out to go deal with that tree. They called it ticket work, or they call it hut work. And so we had crews scattered throughout the county working on individual trees. Meanwhile, the trees that caused these fires were not those ones. They were not the ones that they had identified. These were trees that needed more routine maintenance, but because they had devoted all of their budget and resources to dealing with these problem trees, the utility was unable to get us out to these other locations. So I'd caution about that. Now, the impact of clients who do business in multiple states is this. Remember I said the plaintiff lawyers are generally, I see the same plaintiff lawyers on fire in Texas that I may see in Oklahoma or in Southern California. They too, as do their experts, they know who's got the right kind of program. So if, say, a PG&E in California, let me use San Diego Gas and Electric, let's say SDG&E in Southern California has a great state-of-the-art program, and ABC utility in Oklahoma doesn't have that program, then the lawyers are going to argue they should have it. They should be like San Diego Gas and Electric. So what you find is the states that have the best programs, their programs become the standard of care that's argued by plaintiffs' lawyers.
Well, in theory, at least, that should elevate the practice of vegetation management nationwide, because utilities should be concerned about the liability to themselves for not doing it to best practices, correct?
In theory, correct. But one of the problems is the funding, the resources, and the incentive does not export as well from state to state or utility to utility. We have, as I know you know, Larry, and certainly Steve, we have a series of these co-ops in this country. You see them a lot in the Southwest, and they are utilities that are owned by the customers, and they do not often have the resources to provide the Cadillac of utility vegetation management. Yet they get sued for not having that. So it's got to be tempered, if that makes sense.
Okay. Well, why don't we, I'm going to remove this from the sharing function. And why don't we open this up to questions from the audience? Alex, is that something you can assist me with? Can you, if there are questions from the audience, how do I pull them in?
If you want to answer, put your questions in the chat, I'll be happy to read them out loud.
Great.
While we're waiting, if I may just address one other thing that Stephen brought up. Stephen, this idea of having some kind of system to mediate, especially smaller claims, I think is an excellent one, and I hope you guys can make that happen. I think it is needed. As I indicated, I have been able to, and I'm staying within the bounds of the law, of course. I have been able to defeat class actions for groups of small claimants with property damage because most states realize each individual parcel of real property is deemed unique in and of itself, and you can't really deal with them on a class-wide basis, as well as other reasons. So I encourage that effort and hope it works out.
Thank you. And I think that what you said is important. This is not merely a matter of aggregating a whole bunch of small claims to then go after utility. It just won't work that way, right? Okay. Let's see, there's a question here. Edith, can you touch more on how your background in civil rights impacted the way you handled the situation with your home?
Yes, sure. My background on civil rights is basically just based on who I am as a person. I've always been a person to advocate for an injustice or anything that I saw unfair as a child, as I was in that photograph that you saw when I was 12 years old at the March on Washington. So it's just been who I am. And certainly when I read and then understood that, and I had a law class in college, accounting, but it was law. But when I understood, and then I sold real estate. So when I understood that we had a bilateral agreement. They were going to provide safe, reliable service at what was supposed to be a reasonable rate, and then I was going to pay them. Well, I paid them, but I wasn't getting safe, reliable service. And then for me to end up, our family, for us to lose our home, with a devastating fire that was avoidable. It really didn't require a lot of investigation, if certainly that needed to happen. But the outcome was they failed to exercise their reasonable standard of care. They failed to remove the tree. They failed to do a lot of things. So yes, it's caused me to continue to advocate. But it's me. In answer to your question, it's just who I am. It wasn't right. And then I've seen what it's done to other people, up to people dying because their homes caught fire. And so it's kept me energized to get this changed, because it's somebody's responsibility and they have to answer to that. We can't just let it go because, they're a powerful company.
Right. And Edith, in fact, you and I are working together with the Michigan Attorney General to see if we can start implementing this in Michigan, which hopefully can then be replicated nationwide as well. So I think that is an important development and outgrowth of your civil rights background, the personal experience you had, and the work that we're doing here at Tulane now.
Yes.
Right. I see there's a question from Ryan Anderson, who one of the students that Edith, you and I worked with last year. She's asking. Oh no, that was her question. Sorry. A question from Steve Sissel that's asking Randy, you wouldn't mind saying a few words on this condemnation?
Yeah. Okay. Inverse condemnation is a very interesting theory of law that derives from the Constitution. It's especially prominent here in the wildfire space here in California. And basically, here's what it is. we all have a right not to have our property or lives taken without due process of law. That's why the government, if they want to build a freeway through my backyard, they got to first let me know and pay me for it and pay me value for it. Now, let's say they don't do that. They just go ahead and build the freeway. Well, then I can sue them for what's called inverse condemnation, which is the opposite of direct condemnation, meaning when they came in and bought it. And I'm basically saying, look, you took my property for a public purpose. Under the law, you have to give me just compensation. In California and a few other states, they have expanded that constitutional remedy to include public utilities, especially electrical utilities. Now, as we know, and certainly the law students here know, the 14th Amendment basically protects you from the government doing those things. But some courts, particularly here in California, and I think if they haven't done it, they're getting close in Washington and Oregon, they've recognized, well, public utilities are kind of like governmental agencies, right? They perform a service that no one else really performs in their area. It's like a legalized, legitimate monopoly. They have the right to condemn property, which many of them do in many states. So we're going to treat them like the government, and we're going to allow that inverse condemnation case against them. Now, you may ask, well, who cares? So what? It's just another legal theory. It's very different than suing them for negligence. In inverse condemnation, you don't have to prove that they were at fault. Like I submit, Edith, if you had an inverse condemnation availability in your case, that judge would have had an even harder time dismissing your case because it doesn't require a whole lot more than the public entity, than the plaintiff proving that fire was caused as a result of your facilities acting and operating as they were intended. And if you don't mind, I keep picking on you, Edith, but you have a good example. In Edith's example, they put in power lines that were intended to provide her power and her neighbors. They put them in areas where they knew there were trees. A tree hit a power line, caused the fire. Therefore, the fire happened while the utility was operating as it was intended, meaning a line to deliver power to Edith around trees. And it can be an extremely powerful tool for plaintiffs. It can be an extremely sharp sword for people like my clients, who oftentimes have to sign agreements that they will defend or indemnify the utility for anything that happens as a result of our work. So what happens, utility gets sued for inverse condemnation. They don't have to prove fault. And the plaintiff, and we didn't do anything wrong. My client may not have done anything wrong, but it signed this agreement that says we got to pay the tab. So I've had multiple situations where I could get my client, I could get a jury to release my client, I could get out of the case, but I can't, the case brought by the plaintiffs, but I can't get out of this darn indemnity case that the utility is suing us for, because they got hit for inverse condemnation. There's no fault required. So as a result, my clients end up paying losses that they're not at fault for causing.
We only have, I guess, a minute or two left. I saw several comments suggesting that trees should not be demonized and that they're not really a problem. And we all agree, actually. These are events that are caused by tree and power line conflicts. It's not that the tree is necessarily at fault. We're not advocating for the removal of all trees. What we're suggesting, though, is that there are instances where it's the wrong tree in the wrong place, and that by engaging in right tree, right place plantings, there may be a very, very solid, practical way to avoid these kinds of problems in the future. However, when you look at companies like, for example, PG&E that have 200,000 miles of distribution lines plus another probably 10,000 miles of transmission lines on top of that, you're talking about millions and millions and millions of trees that all need some sort of attention. And that is a massive undertaking. What we're talking about is theoretically re-landscaping the entire country. And that It's probably something that needs to be done, but it's obviously a very, very large problem. But the payoff in the future could be no more wildfires that, or even individual fires that destroy people's homes, property, and cause all number of different kinds of damages, injuries, and deaths. And one of the things that we are looking to investigate. I want to take a moment to say thank you very, very much for all of the hard work that Stephen and Edith and Randy put into the presentation today. I want to thank you for your time and your energy, and I'm looking forward to continuing to work with all of you towards solutions in this area.
Thank you so much for the opportunity again.
Yes, thank you all.
Thank you all for coming, and thanks for the opportunity.
Thank you, everyone.